Can you hear me now? Good. Son of a bitch. I had it in my mind, too, like, I need to unmute the mic. I need to unmute the mic. And then press this button here and that button here, and it's like, poof. Anyways, I hope you guys like the little thing that I came up with to allow you guys to relax and let other tourists get in here and give you a little itinerary of what's going on, how long the stream's going to take, and what we're going to go over while we're in it. So without any further ado, I say we get started on the stream. What do you guys think? So what we're going to do today is we're going to go over the Freedom of Information Act here in Michigan. We're not going to read all of it. It's 15 pages long, and there's quite a bit of exceptions. But yeah, we're gonna read through it real quick, just so people understand. Anybody in Michigan actually understands what's going on here in Michigan with the Freedom of Information Act, including, but not limited to, the fact that it is in violation of our Fourth Amendment right. So, let's get started. So we have the Freedom of Information Act 442 of 1976. It's an act to provide public access to certain public records of public bodies, to remit certain fees, to prescribe the powers and duties of certain public officers and the public bodies, to provide remedies, penalties, and to repeal certain acts and parts of acts. 15.231, short title, Public Policy. This act shall be known and may be cited as the Freedom of Information Act. It is the public policy of this state that all persons except those persons incarcerated in state or local correctional facilities are entitled to full and complete information regarding the affairs of government and the official acts of those who represent them as public officials and public employees consistent with this act. The people shall be informed so that they may fully participate in the democratic process. The people shall be informed so they may fully participate in the democratic process. You know how many times on that video of the FOIA compliance that I did, how many people are saying, oh, you're not, the democratic process, blah, 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 you're getting in the way of their work, blah, 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 blah. Brothers, it's their job. It's their job. We pay them to do it. And you didn't, and these people were not even upset with me being there, so how, I don't understand. I can't even put it into words how stupid these people are. How can you consciously lick the boot? So before we even dive deeper into this, how can you lick the boot, right? When you see videos like Lackluster's that came out today, right? Where this guy, he calls. He's off in another city for work, right? His wife and his 2 kids and his dogs are at home. And he calls because his doorbell cam shows that somebody walked into the driveway and it set off the camera or whatever, gave him a notice. And he calls the non-emergency line, and he doesn't request an officer show up. He just tells them so that just in case somebody else's house got broken into, he might have a picture of this guy, right? So the police show up immediately. This rookie draws his weapon and starts walking around the entire curtilage of the house and the backyard without a warrant, and obviously lacking exigent circumstance because he wasn't there for an emergency call. He starts walking around the house and in the backyard with his firearm drawn, like it's some type of black ops. Like he's walking around like this, y'all, like this, and he goes around the corner. He's like, and then she opens the door to let the dogs out, and he shoots the dog 4 times. He shoots the dog 4 times with the house in the backdrop, the innocent woman in the backdrop, and he freaking, oh my God, y'all! It boils my blood because he handcuffs the innocent person that he almost shot. What kind of sense does that make? Where are the trolls and bootlickers on that video? Where are you? You want to come on my video when I'm doing things that hold our government accountable and make sure that they are doing what they need to do to get paid for what we pay them for, as if they don't already take enough of our taxes, y'all. So we should at least make sure they're doing what they're supposed to be doing, right? All right, now that I got a little bit that out of my system, Let's keep going. If you haven't seen that video from Lackluster yet, I highly recommend you go and watch it. Because, as you know, they investigated themselves and found no wrongdoing. No wrongdoing. Okay. So, definitions, as used in this act, we're not going to go over cybersecurity. We're probably not going to go over... Well, probably, so that cybersecurity is probably like the only thing here. Okay, so... Field name means label or identification of an element of a computer database that contains a specific item of information and includes but is not limited to a subject heading such as a column header, data dictionary, or record layout. FOIA coordinator means either of the following: an individual who is a public body. So essentially what that is saying is if there is no designated or designee for FOIA coordinator for a public body, that everybody in the building is a FOIA coordinator because they are at the public body. 2, an individual designated by a public body in accordance with this section, with Section 6, to accept and process requests for public records under this act. See, a lot of people, a lot of these trolls, they don't understand how to comprehend reading the law. So they'll read this part, but they won't read the part above it. And there's a reason why they're separated. They're separated because they're different. This applies to a public body that has designated a FOIA coordinator. This applies to a public body who has not designated a FOIA coordinator, which makes all of our public servants at that public body FOIA coordinators. Follow me? Follow me? I know it's kind of boring, isn't it? Kind of boring? But whatever. It's got to be known. It's got to be done. You guys should do this with your own FOIA laws. Get your highlighter out. Print it out. Get your highlighter out. Read through it and highlight important aspects of your FOIA documents. There's a lot of power in these documents. A lot of power. A person means an individual, corporation, limited liability company, partnership, firm, organization, association, governmental entity, or other legal entity. Person does not include an individual serving a sentence of imprisonment in a state or county correctional facility in this state or any other state, or in a federal correctional facility. Public body means any of the following: a state officer, employee, agency, department, division, bureau, board, commission, council, authority, or other body in the executive branch of the state government, but does not include the governor or lieutenant governor, the executive office of the governor or lieutenant governor, or employees thereof. An agency, board, commission, or council in the legislative branch of the government, a county, city, township, village, intercounty, intercity, or regional governing body, council, school, district, special district, or municipal corporation, or a board, department, commission, council, or agency thereof. Any other body that is created by state or local authority is primarily funded by or through state or local authority, except the judiciary, including the office of the county clerk and its employees when acting in the capacity of the clerk to the circuit court, is not included in the definition of public body. Public record means a writing prepared, owned, used, in the possession of, or retained by a public body in the performance of an official function from the time it is created. So right here, this law right here, this public record, this part of the public record, this definition, this is what allows us to FOIA request videos or photos from a public servant's phone. Right here. Writing prepared, owned, used, in the possession of, or retained by a public body in the performance of an official function from the time it is created. Very important. Very important. Public record does not include computer software. This act separates public records into the two following classes. Those that are exempt from disclosure under Section 13, which we will probably not be getting into. It's mostly all school stuff and, about privacy for kids and, court proceedings and, just general stuff like that. We're not even really worried about exemptions. All public records that are not exempt from disclosure under Section 13 that are subject to disclosure under this act. So there are exempt and there are non-exempt. That's it. Software means a set of statements or instructions that, when incorporated in a machine-usable medium, is capable of causing a machine or device having information processing capabilities to indicate, perform, or achieve a particular function, task, or result. Software does not include computer-stored information or data or a field name if disclosure of that field name does not violate a software license. Unusual circumstances. Hold on. I got cotton mouth, y'all. Cotton mouth. Hold on. I got this Red Bull over here. I'm going to take a little drink real quick. Hold on. Much better. Unusual circumstances means any one or a combination of the following, but only to the extent necessary for the proper processing of a request. The need to search for, collect, or approximately examine or review a voluminous amount of separate and distinct public records pursuant to a single request. The need to collect the requested public records from numerous field offices, facilities, or other establishments which are located a part of the particular office receiving or processing the request. So these two right here, in unusual circumstances, is essentially saying you can't go to your parks department and request all the body cam from the police and at the same time request your roster of employees from the city hall and then at the same time request the budget from the public works department. It's pretty much saying that we don't have to fulfill those requests. You can go to those public bodies and do them, or do them online, or we're allowed to charge an exorbitant fee to do it. That's essentially what this is saying, and it goes into deeper detail about that later on in the act. But okay, let's continue. Writing means handwriting, typewriting, printing, photostating, photographing, photocopying, and every other means of recording, including letters, words, pictures, sounds, or symbols, or combinations thereof, and papers, maps, magnetic, or paper tapes, photographic films or prints, microfilm, microfiche, magnetic, or punch cards, discs, drums, hard drives, solid-state storage components, or other means of recording while retaining meaningful content. Written request means a writing that asks for information and includes a writing transmitted by facsimile, electronic mail, or other electronic means. Written request, this is important for one of the most important parts in this entire act. 15.233 Public Records, Request Requirements, Right to Inspect, Copy, or Receive, Subscriptions, Forwarding Requests, File, Inspection, and Examination, Memoranda, Abstracts, Rules. You guys get the idea. I'm not going to read the whole title every time. Kind of a pain in the ass. All right. So this is the section right here that is in violation of our Fourth Amendment right. And we're going to try doing something about that. As soon as Livonia runs out of time to deny my appeal, we're going to do something about that. We're going to try taking them to the courts. So as it says, Section 3, Subsection 1, except as expressly provided in Section 13, upon providing a public body's FOIA coordinator with a written request that describes a public record sufficiently to enable the public body to find the record, a person has a right to inspect, copy, or receive copies of the requested public record of the public body. A request from a person, other than an individual who qualifies as indigent under Section 4.2a, must include the requesting person's complete name, address, and contact information. And if the request is made by a person other than an individual, the complete name, address, and contact information of the person's agent who is an individual. That right there. Right there. Violates your Fourth Amendment right. You did not break a law, and there's no reasonable. Remember, the Fourth Amendment says reasonable searches and seizures. There is no unreasonable searches and seizures. So there is no reasonable reason that I can't make a request as a person and give them an email for correspondence and a date that I'm going to pick it up. And if there's any issues, they can extend it and send that to my email. But I'm going to still pick it up in person. There's no reason that they need my name, address, and contact information. None whatsoever. Other than the fact that they want to know who's grabbing this information, if there's criminal cases, if there's a lawsuit against a city, because then they can cross-reference that and possibly try to deny you for it. And if you don't know these laws, they'll get away with it. They'll absolutely get away with it. So let's continue. If the request is made, blah, 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 an address must be written in compliance with the United States Postal Service addressing standards. Now, this right here, this is important because if you're to request certified documents must be sent through certified mail. They have to be. So that is when you would need to provide your address written in compliance with the USPS. That's the only time. Not every time. That's the only time you should need to do that. What are they doing here, y'all? And we just got a new attorney general here in Michigan as well. And from what I've read about her, she seems to be all right. So I'm going to try seeing what she says about this FOIA law here. So contact information must include a valid telephone number or electronic mailing address. So that would be your email. So you don't have to give a telephone number if you're providing an email. I can understand the email. I can understand it. Needs some way to correspond, but at the same time, if I'm just requesting it in person and telling you I'll be back in 2 weeks, you can give me my denial in 2 weeks, if that's the case. If I don't want to give up my Fourth Amendment right, you could give me the denial in person when I come back. I could put it to any name that I want, anonymous. Or we could put a number to it, you know? You know what I'm saying? Like, FOIA request number 30505 or something. You know what I'm saying? You could put a number to it. You could do so many different things to make sure that the right person is getting the right information in the right FOIA request rather than violating their Fourth Amendment right. A person has a right to subscribe to future issuances of public records that are created, issued, disseminated on a regular basis. A subscription is valid for up to 6 months at the request of the subscriber and is renewable. So you can subscribe to that information as it changes. That's how a lot of these guys on YouTube, they will subscribe to the information and it'll automatically get sent to them. For example, my Livonia Snowflake Showdown, all of the body cam, all of the call logs, everything was sent to the email 2 days later, completely free. Completely free. It was nice. Didn't have to hassle for them at all. It was gorgeous. Let's continue. A Freedom of Information Act coordinator shall keep a copy of all written requests for public records on file for no less than 1 year. A public body shall furnish a requesting person a reasonable opportunity for inspection and examination of its public records and shall furnish reasonable facilities for making memoranda or abstracts from its public records during the usual business hours. A public body may make reasonable rules necessary to protect its public records and to prevent excessive and unreasonable interference with the discharge of its functions. A public body shall protect its public records from loss, unauthorized altercation, mutilation, or destruction. So this right here is what makes it essentially a crime. There is a crime that's somewhere in here. We'll find it. We'll go over it. When we see it, we'll find it. But this is what makes it a crime for them to delete a picture of you after they have taken it while they are on duty. On the clock, on duty. Public servants have a duty. Police officers have a duty. Firefighters have a duty to the people. They have a duty to the people. We have rights, they have duties until they are off the clock. This act does not require a public body to make a compilation, summary, or report of information except as required in Section 11. This act does not require a public body to create a new public record except as required in Section 11. And to the extent by this act for the furnishing of copies or edited copies pursuant to Section 14 of an already existing public record. The custodian of a public record shall, upon written request, furnish a requesting person a certified copy of a public record. Doesn't really tell you how much those public records cost. I don't remember seeing this in any of the papers. 15.234, fee, limitation on total fee, labor costs, establishment of procedures and guidelines, creation of written public summary, detailed itemization, availability of information on the website, notification to requester. I told you I wasn't going to read the whole thing. Okay. Section 4, subsection 1, a public body may charge a fee for a public record search. For the necessary copying of public record for inspection, or for providing a copy of a public record if it has established, makes publicly available, and follows procedures and guidelines to implement this section as described in subsection 4. Subject to subsections 2, 3, 4, 5, and 9, that fee must be limited to the actual mailing costs and to the actual incremental costs of duplication or publication, including labor, the cost of search, examination, review, and the deletion and separation of exempt from non-exempt information as provided in Section 14. Except as otherwise provided in this Act, if the public body estimates or charges a fee in accordance with this Act, the total fee must not exceed the sum of the following components. So, these components right here is what the detailed itemization is. So these are required to be given to you free of charge when you request them at the public body or when you submit a written request. So, A, the portion of labor costs directly associated with necessary searching for, locating, and examining of public records in conjunction with receiving and fulfilling a granted written request. The public body shall not charge more than the hourly wage of its lowest paid employee capable of searching for, locating, and examining the public records in the particular instance, regardless of whether that person is available or who actually performs the labor. Labor costs under this subdivision shall be estimated and charged in increments of 15 minutes or more, with all partial time increments rounded down. B, the portion of labor costs, including necessary review, if any, directly associated with the separating and deleting of exempt information from non-exempt information as provided in Section 14. For services performed by an employee of the public body shall not charge more than the hourly wage of its lowest paid employee capable of separating and blah, 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 blah in Section 14. We just read that. There's a couple of, that's probably going to be in all of them. I think that is in all of them under Section 14. Okay, let's keep going. Let's skip this. If a public body does not employ a person capable of separating, deleting the exempt information from non-exempt information in the particular instance as provided in Section 14, I lost where I was. As determined by the public body's FOIA coordinator on a case-by-case basis, it may treat necessary contracted labor costs used for the separating and deleting of exempt information. If you guys want to read all of this, you can. But I'm going to, because it's really this right here. It's like the first sentence of all these is what really matters. This is just like the breakdown, the description of that. So we're gonna do the first sentence because this is gonna go too long, I think, if I do the whole thing. So let's keep going. For public records provided to the requester on any form of non-paper physical media, the actual and most reasonably economical cost of the non-paper physical media. D. For paper copies of public records provided to the requester, the actual total incremental cost of necessary duplication or publication, not including labor. E. The cost of labor directly associated with duplication or publication, including making paper copies, digital photocopies, or transferring digital public records to be given to the requester on a non-paper physical media or through the internet or other electronic means as stipulated by the requester. F. The actual cost of mailing, if any, for sending the public records in a reasonably economical and justifiable manner. The public body shall not charge more for expedited shipping or insurance unless specifically stipulated by the requester, but may otherwise charge for the least expensive form of postal delivery confirmation when mailing public records. Subsection 2. When calculating labor costs under subsection 1A, B, or E, fee components shall be itemized in a manner that expresses both the hourly wage and number of hours charged. The public body may also add up to 50% to the total applicable labor charge amount to cover or partially cover the cost of fringe benefits if it clearly notes the percentage multiplier used to account for benefits in the detailed itemization described in subsection 4. skip forward a little bit. If you guys want to read all of this through, if anybody's in Michigan and wants to actually read it all through, you can. It's legislature.michigan.gov has this PDF. You can download it for free and print it out for free, obviously. An individual who is entitled to the information under this act and who submits an affidavit stating that the individual is indigent and receiving specific public assistance, or if not receiving public assistance, stating facts showing inability to pay the cost because of indigency. If the requester is eligible for a requested discount, the public body shall fully note the discount on the detailed itemization described under subsection 4. If a requester is ineligible for the discount, the public body shall inform the requester specifically of the reason for ineligibility and the public body's written response. And an individual is ineligible for this fee reduction if any of the following apply. If you are indigent, this applies to you. Skip down to B. A nonprofit organization formally designated by the state to carry out activities under Subtitle C of the Developmental Disabilities Assistance and Bills of Rights Act of 2000, Public Law 106-402, and the Protection and Advocacy for Individuals with Mental Illness Act, Public Law 99-319, or their successors if the request meets all the following requirements. Is made directly on behalf of an organization or clients, is made for a reason wholly consistent with the mission and provisions of those laws under Section 931 of the Mental Health Code 1974, PA 258 MCL 330.1931, is accompanied by documentation of its designation by the state if requested by the public body. A fee as described in subsection 1 shall not be charged for the cost of search, examination, review, and the deletion and separation of exempt from non-exempt information as provided in section 14, unless failure to charge a fee would result in unreasonably high cost to the public body because of the nature of the request in the particular instance, and the public body specifically identifies the nature of those unreasonably high costs. Subsection 4. Now this is the important one. Very, very important. Subsection 4. A public body shall establish procedures and guidelines to implement this act, the entire act, not just this subsection, Act 442. A public body shall establish procedures and guidelines to implement this act and shall create a written public summary of the specific procedures and guidelines relevant to the general public regarding how to submit written requests to the public body and explaining how to understand a public body's written responses, deposit requirements, fee calculations, and avenues for challenge and appeal. The written public summary shall be written in a manner so that it is easily understood by the general public. If the public body directly or indirectly administers or maintains an official internet presence, it shall post and maintain the procedures and guidelines and its written public summary on its website. A public body shall make the procedures and guidelines publicly available by providing free copies of the procedures and guidelines and its written public summary, both in the public body's response to a written request and upon request by visitors at the public body's office. At the public body's office upon request. It doesn't say upon written request by visitors at the public body's office. It just says upon request. So that could include written, that could include verbal, that could include me writing it down or you writing it down and it becomes a written after I tell it to you. There's definitions for this, y'all. There's definitions. Definitions, trolls. You got to read the whole damn thing. All right? Christ. What happened to my chat? Where's my chat? There's my chat. Hey, Audit Thumbs in here. Hey, what's up, brother? All right, so let's keep going. A public body that posts and maintains procedures and guidelines and its written public summary on its website may include the website links to the document in lieu of providing paper copies in its response to a written request. In its response to a written request, it may include the website link and documents, the website link to the documents in lieu of providing paper copies. So now this is why they may do that. Do you see this? Do you see this document here? Look at this document. You see this thing? It's a beast. Now, to properly send this document in the mail, especially as a certified copy, you'd get a packet in the mail, and it would cost the taxpayers more to send that packet. Now, if you requested it through an email, and they didn't send it as a link, this whole packet is going to get sent through the email. And if any of you knows what formatting is, it doesn't transfer from PDF to email. So this is all going to be misjumbled. These tabs where it changes sections, that's not going to be there. It's not going to look right. It's not going to. So, I mean, yeah, sure. You could tell them, yeah, I want you to copy and paste it into my email. It's possible. You can request it that way. Sure. And they'll do it for you, but it's not going to look very good. It just says they may. It says they may do that. Right here. It says may. May. Very important that you pay attention to every word that they use. They may include the website link to the documents in lieu of providing paper copies to a response to a written request only. They can't just give me a link to the documents when I'm there in person requesting it at the public body's office as a visitor. They can't just hand me a link and shoo me off to the website. That's what this law says. This law says they cannot shoo you off to the website for this stuff if you are there in person. Let's continue. A public body's procedures and guidelines must include the use of a standard form for detailed itemization of any fee amount and its responses to written requests under this act. The detailed itemization must clearly list and explain the allowable charges for each of the 6 fee components listed under subsection 1. Those are the A through F that we just went through. We'll give you a roundup here. We'll go back real quick, and we'll give you a refresher. So this is 1. This is 2. So this is subsection 1. Section 4 is subsection 1. This is 2. This is 3. This is 4. This is 5, and this is 6. Listed under subsection 1 that compose the total fee for using estimated or charging purposes. Other public bodies may use a form created by the Department of Technology, Management, and Budget, or create a form of their own that complies with this subsection. A public body that has... Okay, let me stop real quick. Another very, very important piece of language here in this law. This gives us all the power. If we check up on them and we send this to AG, they cannot be charging fees if they are not in compliance with this section, with this subsection of the act. They cannot charge fees for anything at all, because without this permission in this subsection, they don't have the authority to charge fees. So let's continue. A public body that has not created or that has not established procedures and guidelines, has not created a written public summary, or has not made those items publicly available without charge as required in this subsection, is not relieved of its duty to comply with any requirement of this act and shall not require deposits or charge fees otherwise permitted. Shall not require deposits or charge fees that are otherwise permitted under this act. Not this subsection, the entire act. Any part of the act that gives them permission to charge fees is null and void if they are not in compliance with this subsection. Notwithstanding this subsection, so doesn't only include this subsection is pretty much what they're saying. And despite any law to the contrary, if they have an ordinance on the books for the city or if there's a municipal code or whatever, despite any law to the contrary, a public body's procedures and guidelines under this act are not exempt public records. Period. Well, not period. Under Section 13, period. But this is just to tell you where that would be. There could be a period here, and that would be justifiable. Under this act, are not exempt public records. They are not exempt in any part of the law. None. Despite any law to the contrary. Powerful language. Let's continue. Subsection 5. If a public body directly or indirectly administers or maintains an official internet presence, any public records available to the general public on that internet site at the time the request is made are exempt from any charges under subsection 1b. If the FOIA coordinator knows or has any reason to know that all or portion of the requested information is available on its website, the public body shall notify the requester in its written response that all or a portion of the requested information is available on the website. It says it shall notify. Doesn't mean it has to go through the website. It just says they shall notify the requester. Maybe make it easier. And the requester has the right to ask for it as a paper document sent through the mail. The written response, to the degree practicable in the specific instance, must include a specific web page address where the requested information is available. On the detailed itemization described in subsection 4, the public body shall separate the requested public records that are available on its website from those that are not available on the website, and shall inform the requester of the additional charge to receive copies of the public records that are available on its website. If the public body has included the website address for a record in its written response to the requester, and the requester thereafter stipulates that the public record be provided to him or her in a paper format or other form as described under subsection 1c, the public body shall provide the public records in the specific format, but may use a fringe benefit multiplier greater than the 50% limitation in subsection 2, not to exceed the actual cost of providing the information in specific format. Subsection 6, if a public body may provide requested information available in public records without receipt of a written request. What's that mean? Can anybody tell me what that means? It's pretty much saying that you could tell them, you can make an oral request. May provide requested information available in public records without receipt of a written request. What's that telling you? Think about it. Think about it nice and hard. Let's continue. If a verbal request for information is for information that a public body believes is available on the public body's website, the public employee shall, where practicable and to the best of the public employee's knowledge, inform the requester about that public body's pertinent website address. It does not say anywhere here, it doesn't say anywhere here that they can force you to go to the internet while you're at the public body. Nowhere does it say that. It says inform the requester. And maybe the requester doesn't want to go to the website address. 7. If a verbal request for information is for information that a public body believes is available on the public body's website. I just read that. My bad. 8. And either the public body's initial response or subsequent response as described in section 5, subsection 2D, the public body may require a good faith deposit from the person requesting information before providing the public records if the requester if the entire fee, estimate, or charge authorized under this section exceeds $50. Based on good faith calculation of the total fee described in subsection 4, probably not going to go through all the fee breakdowns and itemizations. You guys, for the most part, are in different states that have different fees. Read your FOIA. Read your FOIA. Let's skip down here. The time frame estimate non-binding to the public body, the public records, but the public body shall provide the estimate in good faith and strive to be reasonably accurate and to provide the public records in a manner based on the state's public policy under section 1 and the nature of the request in a particular instant. If the public body does not respond in a timely manner as described under section 5, it is not relieved from its requirements to provide proper fee calculations in time frame estimates and any tardy responses. Providing an estimated time frame does not relieve a public body from any of the other requirements of this act. If a public body does not respond to a written request in a timely manner as required in section 5, subsection 2, the public body shall do the following. A. Reduce the charges for labor costs otherwise permitted under this section by 5% each day the public body exceeds the time permission under section 5, section 5, subsection 2, for a response to the request with a maximum of 50% reduction if either of the following applies. The late response was willful and intentional. The written request included language that conveyed a request for information within the first 250 words of the body of a letter, facsimile, electronic mail, or electronic mail attachment, or specifically included the words, characters, or abbreviations for the freedom of information, FOIA, copy, or recognizable misspelling of such, or appropriate legal code reference for this act on the front of an envelope or in the subject line of an electronic mail, letter, facsimile, or cover page. This is essentially telling you that you do not need a standard form. It's pretty much telling you here that if you can convey it in 250 words of the body of a letter, if it says freedom of information, FOIA, copy, or recognizable misspelling of such, it could be on the front of an envelope. And whatever's inside of the envelope can be your request, is essentially what that's saying. If a charge reduction is required under subdivision A, you want me to read the fees? You want me to read the fees, man? I'll read the fees, but the fees are a pain in the ass. All right, let's go back up to these fees here. Based on good faith calculation of the total fee in the subsection subject to subsection 10, the deposit must not exceed half of the total estimated fee, and a public body's request for the deposit may include detailed itemization as required under subsection 4. The response must also contain best efforts estimate by the public body regarding the time frame it will take the public body to comply with the law in providing the public records to the requester. The time frame estimate is non-binding upon the public body, but the public body shall provide the estimate in good faith and strive to be reasonably accurate. So I read the rest of that. But Audit Them wants me to read the fees, so I guess I'll read the fees, man. I'll read the fees. How long are we into this now? How long are we into this? Can somebody tell me how long we are into this live so far? "46 minutes into the live already? Holy shit. How am I 46 minutes in already? I guess the itinerary ain't gonna work out, but we're still gonna watch some Judge FLEISCHER. I think you guys will love Judge FLEISCHER. It'll be the little surprise for you. All right. I don't remember where I was now. I'm down here somewhere. Yep, down here. If the charge reduction is required under subdivision A, fully note the charge reduction on the detailed itemization described under subsection 4. This section does not apply to public records prepared under an act or statute specifically authorizing the sale of those public records to the public, or if the amount of the fee for providing a copy or the public record is otherwise specifically provided by an act or statute. Section 11. Subsection 11. Subject to subsection 12, after a public body has granted and fulfilled a written request from its individual under this act, if the public body has not been paid in full the total amount under subsection 1 for the copies of public records that a public body made available to the individual as a result of that written request, the public body may require a deposit of up to 100% of the estimated fee before it begins a full public record search for any subsequent written request from the individual if all of the following apply. The final fee for the prior written request was not more than 105% of the estimated fee. The public records made available contained in the information being sought in the prior written request and are still in the public body's possession. The public records were made available to the individual, subject to payment, within the time frame estimate described under subsection 8. 90 days have passed since the public body notified the individual in writing that the public records were available for pickup or mailing. The individual is unable to show proof of prior payment to the public body. The public body calculates a detailed itemization as required under subsection 4 that is the basis for the current written request increase estimated fee deposit. Subsection 12. A public body shall no longer require an increased estimated fee deposit from an individual as described under subsection 11 if any of the following apply. The individual is able to show proof of prior payment in full to the public body. The public body is subsequently paid in full for the applicable prior written request. 365 days have passed since the individual made the written request for which full payment was not remitted to the public body. 13. Subsection 13. A deposit required by a public body under this act is a fee. You guys can be absolute goofballs all you want in the chat. I'll catch up with you. I'll catch up with the chat. It's in the itinerary at the end. I'm watching you. I'm just hardly replying. I'm glancing. Don't get me wrong. Okay, so they talked a lot about subsection 14 now. Why would they do that? Let's find out. Subsection 14. If a deposit that is required under subsection 8 or 11 is not received by the public body within 45 days from receipt by the requesting person of the notice that a deposit is required, and if the requesting person has not filed an appeal of the deposit amount pursuant to section 10A, the request shall be considered abandoned by the requesting person, and the public body is no longer required to fulfill the request. Notice of a deposit requirement under subsection 8 or 11 is considered received 3 days after it is sent, regardless of the means of transmission. So this is pretty much allowing them to say, oh, yep, we sent it in the mail. We sent it in the mail. It didn't get to you? Oh, that's too bad. Notice of a deposit requirement under subsection 8 or 11 must include notice of the date by which the deposit must be received, which date is 48 days after the date the notice is sent. Constitutionality. The disclosure of public records under the Freedom of Information Act impartially to the general public for the incremental cost of creating the record is not a granting of credit by the state in aid of private persons and does not justify non-disclosure on the theory that the information is proprietary information belonging to a public body. Kestenbaum versus Michigan State University. 15.235, request to inspect or receive copy of public record, response to request, failure to respond, damages, contents of notice, denying request, signing notice of denial, notice extending period of response, action by requesting person, law enforcement records management system, alternate responses. Section 5, subsection 1, except as provided in section 3, a person desiring to inspect or receive a copy of a public record shall make a written request for the public record to the FOIA coordinator of a public body. A written request made by facsimile, electronic mail, or other electronic transmission is not received by a public body's FOIA coordinator until 1 business day after electronic transmission is made. However, if a written request is sent by electronic mail and delivered to the public body's spam or junk mail folder, the request is not received until 1 day after the public body first becomes aware of the written request. So this is pretty much saying that you could send your FOIA request into a public body, and if it goes to their spam or junk folder, it's not considered received until they see it. So it could be 60 days, and they could use the excuse, oh, it was in the junk folder. So 61 days is when they first become aware of the written request. That's what that's saying. So if there's a way to prove that, I couldn't tell you. I don't think there's a way for us to prove that. Run, Tom, run! Unless otherwise agreed to in writing by the person making the request, a public body shall, subject to subsection 10, respond to a request for public record within 5 business days after the public body receives a request by doing one of the following: granting the request, issuing a written notice to the requesting person denying the request, granting the request in part and issuing a written notice to the requesting person denying the request in part, issuing a notice extending for not more than 10 business days the period during which the public body shall respond to the request. A public body shall not issue more than one notice of extension for a particular request. Failure to respond to a request under subsection 2 constitutes a public body's final determination to deny the request if either of the following applies. The failure was willful and intentional. And B, the written request included language that conveyed a request for information within the first 250 words of the body of a letter, facsimile, electronic mail, or electronic mail attachment, or specifically included the words, characters, or abbreviations for freedom of information, FOIA, copy, or recognizable misspelling or such, or an appropriate legal code referencing to this act, on the front of an envelope in the subject line of an electronic mail, letter, or facsimile cover page. Subsection 4. In civil action to compel a public body's disclosure of public record under Section 10, the court shall assess damages against the public body under Section 10, subsection 7, if the court has done any of the following. A. Determine that the public body has not complied with subsection 2. B. Order the public body to disclose or provide copies of all or a portion of the public record in question. Subsection 5. A written notice denying a request for a public record in whole or in part is a public body's final determination to deny the request or portion of that request. The written notice must contain A. An explanation of the basis under this act or other statute for the determination that the public record or portion of that public record is exempt from disclosure, and if that is the reason for denying all or a portion of the request. B. A certificate that the public record does not exist under the name given by the requester or by another name reasonably known to the public body, if that is the reason for denying the request or a portion of the request. C. A description of a public record or information on a public record that is separated or deleted under Section 14, if a separation or deletion is made. D. A full explanation of the requesting person's right to do either of the following. I. Submit to the head of the public body a written appeal that specifically states the word appeal and identifies the reason or reasons for reversal of the disclosure denial. Seek judicial review of the denial under Section 10. Notice E. Notice of the right to receive attorney's fees and damages as provided in Section 10 if, after judicial review, the court determines that the public body has not complied with the section and orders a disclosure of all or a portion of a public record. The individual designated in Section 6 as responsible for the denial of a request shall sign the written notice of denial. This is saying that the denial is not valid if it is not signed. A public body issues a notice extending the period for its response to a request. The notice must specify the reasons for the extension and the date which the public body will do one of the following. A. Grant the request. B. Issue a written notice to the requestor denying the request. Grant the request in part and issue a written notice to the requestor denying the request in part. And now subsection 8. I thought there was a D there. Subsection 8. If a public body does or makes a final determination to deny in whole or in part a request to inspect or receive a copy of a public record or portion of that public record, the requesting person may do either of the following. Appeal the denial to the head of the public body under Section 10. Commence a civil action under Section 10. And 9. Notwithstanding any other provision to this act to the contrary, a public body that maintains law enforcement records management system and stores public records for another public body that subscribes to law enforcement records management system is not in possession of, retaining, or the custodian of a public record stored on behalf of the subscribing public body. If the public body that maintains a law enforcement records management system receives a written request for a public record that is stored on behalf of a subscribing public body, the public body that maintains the law enforcement records management system shall, within 10 business days after the receipt of the request, give written notice to the requesting person identifying the subscribing body and stating that the requesting person shall submit the request to the subscribing public body. As used in this subsection, law enforcement records management system means data storage system that may be used voluntarily by subscribers, including any subscribing public bodies, to share information and facilitate intergovernmental collaboration in the provision of law enforcement services. So here's subsection 10. A person making a request under subsection 1 may stipulate that the public body's response under subsection 2 be electronically mailed, delivered by facsimile, or delivered by first-class mail. This subsection does not apply if the public body lacks the technological ability to provide an electronically mailed response. 15.236 FOIA Coordinator. Section 6, subsection 1. A public body that is a city, village, township, county, or state department, or under the control of a city, village, township, county, or state department, shall designate an individual as the public body's FOIA coordinator. The FOIA coordinator shall be responsible for accepting and processing requests for the public body's records under this act and shall be responsible for approving a denial. Shall be responsible for approving a denial. Yeah. Under Section 5, subsection 4, commissioners and subsection 5. Yeah, so let me just reread that real quick. The FOIA coordinator shall be responsible for accepting and processing requests for the public body's public records under this act and shall be responsible for approving a denial under Section 5, subsection 4 and 5. In a county not having an executive form of government, the chairperson of the County Board of Commissioners is the designated FOIA coordinator for that county. For all other public bodies, the chief administrative officer of the respective public body is designated public body's FOIA coordinator. A FOIA coordinator may designate another individual to act on his or her behalf in accepting and processing requests for the public body's records and in approving a denial under Section 5, subsection 4 and 5. This is pretty much saying you can have a designee. A FOIA coordinator can have a designee. Options by requesting person, appeal, actions, and public body. Judicial review, civil action. Section 10, subsection 1. If a public body makes a final determination to deny all or a portion of a request, the requesting person may do one of the following at his or her option. So, like, this stuff is kind of pretty, important, I should say, because this is where, if they're doing you wrong, this is where you would get the power to take them to court. So this is another very important part of the FOIA that you guys should learn in your state. If anybody here is here in Michigan, this applies to you as well. You can submit to the head of the public body a written appeal that specifically states the word appeal and identifies the reason or reasons for reversal of the denial. B. Commence a civil action in the circuit court, or if the decision of a state public body is at issue, the court of claims to compel the public body's disclosure of the public records within 180 days after a public body's final determination to deny a request. Section 2, or subsection 2. Within 10 business days after receiving a written appeal pursuant to subsection 1A, the head of a public body shall do one of the following. Reverse the disclosure denial. B. Issue a written notice to the requesting person upholding the disclosure denial. C. Reverse the disclosure denial in part and issue a written notice to the requesting person upholding the disclosure denial in part. So if you see a pattern here, it's always fully approve, fully deny, or partially approve, partially deny. Always. Always. Under unusual circumstances, issue a notice extending for not more than 10 business days, the period during which the head of the public body shall respond to the written appeal. The head of a public body shall not issue more than one notice of extension for a particular written appeal. A board or commission that is the head of a public body is not considered to have received a written appeal under subsection 2 until the first regularly scheduled meeting of that board or commission following submission of the written appeal under subsection 1A. If the head of the public body fails to respond to a written appeal pursuant to subsection 2, or if the head of the public body upholds all or a portion of the disclosure denial that is the subject of the written appeal, the requesting person may seek judicial review of the non-disclosure by commencing a civil action under subsection 1B. And that's pretty much where I'm at with Lansing right now, because I am not giving them my information. I am refusing to give them my name and address. And I told them, if it's a denial, I'm going to commence civil action. Because, and this guy was trying to tell me, there's case law to it, blah, 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 blah. You're not going to sit here and tell me that you brought the Fourth Amendment in front of a federal or state circuit court, and they told you that that was constitutional. You're not going to sit here and tell me that, Mr. Attorney, Mr. Esquire of the Livonia City Hall. You're not going to sit here and tell me that a judge said that that's constitutional, that I have to give up my Fourth Amendment to receive public information? Because if that was the case, I feel like every single state would require that. Because why wouldn't they want to know who's requesting the information just in case that person's trying to file a lawsuit on them and they can try to hold it from them or retaliate against them? Why wouldn't they want to do that? Why don't other states do that? Because it's unconstitutional. It's a violation of your Fourth Amendment. Doesn't matter if it says that in the MCL. Luckily, it's at the very beginning, and you could just be like, yeah, right here. It says it right there. Yeah. Yeah, it says I have to give up my Fourth Amendment right to get public information here in Michigan. Yeah. No. 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 Okay, let's keep going. Who's sleeping? Who's sleeping, Keith? A board or commission that is the head of a public body is not considered to have received a written appeal under subsection 2 until the first regularly scheduled meeting of that board commission following a submission of the written appeal under subsection 1A. If the head of the public body fails to respond to a written appeal pursuant to subsection 2, or if the head of the public body upholds all or a portion of the disclosure, I just read all that. My bad. In an action commenced under subsection 1B, a court that determines a public record is not exempt from disclosure shall order the public body to cease withholding or to produce all or a portion of the public record wrongfully withheld, regardless of the location of the public record. Venue for an action against a local public body is proper in the circuit court for the county in which the public record or an office of the public body is located has a venue over the action. The court shall determine the matter de novo, and the burden is on the public body to sustain its denial. The court, on its own motion, may view the public record in controversy in private before reaching a decision. Failure to comply with an order of the court may be punished as contempt of court. So this section here, right here, is telling you that if you take this to court, and if you take this to court over denial, and the court sides with you, and they continue to deny and withhold your information, you can have that FOIA officer held in contempt of court. You can have him sent to jail. I mean, I'm not for taking away people's freedoms. That's not me. I don't want to do that. I want people to be more educated. I want to bridge the gap between our public servants, our law enforcement, and the public. There's no reason we should have this amount of disdain. There's no reason that there should be this amount of disdain for auditors, for people who want to go and exercise our rights in public buildings. It should be celebrated. I can't believe that there's Dr. Dave with 200,000 subscribers, and then there was Schrodinger's cat with however many subscribers he had. Bunch of idiots spewing nonsense. Literal nonsense. They don't open a book. They don't open the law. They don't say anything about the law. They just cut and splice, y'all. Cut and splice, make us look like idiots just for their clicks and views. But ironically, they say that's all we're about is clicks and views. Come on. At least we want accountability and transparency in our government, which is corrupt and out of freaking control. Christ. All right. An action commenced under this section and appeal from the action commenced under this section shall be assigned for hearing and trial or for an argument at the earliest practicable date and expedited in every way. If a person asserting the right to inspect, copy, or receive a copy of all or a portion of the public record prevails in an action commenced under this section, the court shall award reasonable attorney fees, costs, and disbursements. If the person or public body prevails in part, the court may, in its discretion, award all or an appropriate portion of the reasonable attorney fees, costs, and disbursements. The award shall be assessed against the public body liable for damage under subsection 7. Subsection 7, if the court determines an action commenced under this section that the public body has arbitrarily and capriciously violated this act by refusal or delay in disclosing or providing copies of a public record, the court shall order the public body to pay a civil fine of $1,000, which shall be deposited into the general fund of the state treasury. The court shall award, in addition to any actual or compensatory damages, punitive damages in the amount of $1,000 to the person seeking the right to inspect or receive a copy of a public record. So this is pretty much saying they're only going to give you $1,000 if you win. Oh man, that's bad. That's bad, because like an attorney is like double that at least. Anyways. Damage should not be assessed against an individual, but shall be assessed against the next succeeding public body that is not an individual that kept or maintained the public record as part of its public function. This is about fees and excess amount. You should read this subsection 240A if you get into that situation where you think you are being misled. You should read this. I am going to skip over it. I am going to skip over that part. 15240B, failure to comply with act in a civil fine. If the court determines in an action commenced under this act that a public body willfully and intentionally failed to comply with this act or otherwise acted in bad faith, the court shall order the public body to pay, in addition to any other award or sanction, a civil fine of not less than $2,500 or more than $7,500 for each occurrence. In determining the amount of a civil fine, the court shall consider the budget of the public body and whether the public body has previously been assessed penalties for violations of this act. The civil fine shall be deposited in the general fund of the state treasury. So, this is punishing anybody who fails to comply with any part of this act. Right here. If they fail to comply with their detailed itemization and their public written summary, they get charged directly out of their budget, comes right out of their budget and goes right into the state treasury to be used for other purposes. Why? Because that's our money. And if it's not being used properly, the state treasury is going to take it and use it properly because it's our money. It's not their money. It's ours, the taxpayer. We the people. We the effing people. All right? It's ours. So this is another part right here, 15.241, matters required to be published and made available by state agency, form of publications, effective matter. Section 11, subsection 1, a state agency shall publish and make available to the public all of the following: final orders or decisions in contested cases and the records on which they were made, promulgated rules, other written statements that implement or interpret laws, rules, or policy, including but not limited to guidelines, manuals, and forms with instructions adopted or used by the agency in the discharge of its functions. Subsection 2, publications may be in electric format or in pamphlet, loose leaf, or other appropriate form in printed, mimeographed, or other written manner. A state agency shall publish and make available to the public all of the following: shall publish. Shall publish. Shall publish in electronic format, in pamphlet, in loose leaf, or other appropriate form in printed, mimeographed, or other written manner. Shall publish. Doesn't say by writ, doesn't say by word. It says it shall publish. It has to be somewhere. It has to be in a pamphlet. It has to be on their website. It has to be on a loose leaf piece of paper. It has to be somewhere. It has to. So this is exemptions, and we are going to skip the exemptions unless you need them, and that's essentially the end of this right here. So we're going to take a little 5-minute break, little 5-minute break. You guys take a stretch here. Take a stretch, and we'll get into Judge Fleischer right after this break. Yeah, I can read that again real quick, audit them real quick. Okay, so up here, where the hell was it? Those are all exemptions. Gotta go up, gotta go up. Gotta go up right here. So it says, Publications may be in electronic format or in pamphlet, loose leaf, or other appropriate form in printed, mimeograph, or other written manner. So it's essentially saying, shall publish and make available to the public all of the following. These three: final orders, decision in contested cases, so essentially denials that were, or partial denials that were contested, promulgated rules, and other written statements that implement or interpret laws, rules, or policy. They may be in electronic format, which means they could be online, or in a pamphlet at the public body, loose leaf at the public body, or other appropriate form in printed, public body, mimeographed, public body, or other written manner, which could include electronic format for written manner, according to the definitions. But it shall be published, shall publish, and make available to the public. So at the public body or on its website, and if it's on the website, it needs a link. This is what I was trying to explain to the lady at the Treasury in Livonia. This publication of these three things, they need a link if it's on the website, because it needs to be published. Shall publish and make available. Right. But that's what I was saying. Like, it could either be in the pamphlet at the place, or they can put the direct link to these three things on a piece of paper or QR code or something like that, that would bring somebody to that website, because it doesn't specifically say that it has to be in physical form at the public body. But y'all, get a stretch in. We're going to watch some FLEISCHER after this, and we're going to be right back. I would smoke a cigarette on the live stream, but I know how YouTube feels about smoking cigarettes on your live stream, and I'm just not going to do it. I'm going to smoke a cigarette. I'll be right back, and then we're going to start with Judge FLEISCHER. And I think you guys are going to love this guy, because I've been watching the shit out of him. And if you guys do like this guy, we will make a segment on the channel dedicated to putting this guy on our channel, because he's pretty interesting. I like him. He's a character for sure. But we're going to be right back. I'm going to smoke this square, cigarette, whatever you call it, and we'll get right back into it. Go get a drink, stretch, do your thing. Be right back. All right, and we're back. Let's get into it here, Judge Fleischer. So now this guy, he posts his live Zoom hearings every day. So if you guys like this content, I can bring you some good content from Judge Fleischer every single week. So you guys let me know what you think in the comment section or in the live chat, and let's get started.
Morning, Mr. Dowdy. You were charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. I'm curious because you picked up a very serious aggravated kidnapping, and I want to know what happened because I want to know how dangerous you are, if at all, and or what type of conditions to put on you. So you have the right to remain silent. Anything you say can or will be used against you. Please.
Yes, Judge. On October 1st in 2024, officers conducted surveillance attempting to locate a wanted felon and had a positive identification at a residence in Harris County, Texas. The officers surrounded the house in fully marked vehicles and began to loudly hail on the PA, calling the defendant by name from the front of the residence. The officers announced themselves, stated they had a warrant, and advised the defendant to come to the front door with nothing in his hands. The officers observed the defendant exiting the back door and flee over a fence. The defendant continued over 2 fences as the officers gave chase in full uniform, telling the defendant to stop and get on the ground. The officers were able to catch up to the defendant as he was fleeing through a backyard and get him to the ground. The defendant evaded for approximately 100 yards.
Okay, what happened with the aggravated kidnapping, please?
The aggravated, you want to read the PC on that?
Yeah.
It's pretty long, Judge.
Just, I guess, a brief synopsis. You don't have to.
There's a brief summary on this, Judge.
Okay.
On September 18, 2024, the complainant and the defendants agreed to meet up to smoke. The complainant stated the defendant drove up to him in a white sedan, all pointed guns at him, and drove him to a park. The defendant struck him in the head with a pistol. At the park, defendant Dowdy took him out and punched him before making him strip naked. Defendant Howard remained in car while at the park. Complainant recognized one as Draco, a man that he went to high school with, and another as Jonah. The complainant said he recently moved back to the area and was nervous about doing so because this group blamed him for the death of one of their friends.
So what I'm going to do, Mr. Dowdy, is that if you are able to make bond, my conditions will mirror the conditions in the felony case. As far as I see now, you are to have a GPS monitor, not to be in possession of a firearm, and you're ordered under house arrest. I will mirror those conditions as well. And I want you to know, Mr. Dowdy, I'm going to do everything in my power to protect my public. And if that means putting you down, I'm going to do it in a heartbeat. Do you understand?
Yes, sir.
So you are not allowed out prior to release without a GPS monitor, and you'll be under house arrest. No weapons, and that's it. But if I find that you violate any conditions, I'm going to make your bond so high that your treads are going to fall out. You understand?
Yes, sir.
All right. Good luck to you, sir.
Thank you, Judge.
Thanks, Mr. No. No. What?
It was,
What?
I was in the passenger seat.
Stop. Don't. We'll get there.
I don't want to see you either.
Ms. Jackson, you now stand charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Yes, Judge. On September 26, 2024, officers conducted a traffic stop on a vehicle bearing an expired agent tag. Officers made contact with the occupants of the vehicle. Defendant Cephas was arrested for a DWLI, and defendant Jackson had active warrants out of Webster PD. Officers conducted an inventory of the vehicle and located 2 small black bags containing a green leafy substance on the passenger side where defendant Jackson was sitting, and a backpack containing a firearm in the trunk. Substance was identified as marijuana based on training and experience. The weight was 4 grams or 0.141 ounces. The defendants denied ownership of both. The defendants were identified with Texas driver's license.
Okay, I have so many questions.
Yes, Judge.
So first off, you said defendants,
Yes,
plural.
there are 2 defendants, Your Honor.
So the driver,
Yes, Your Honor.
okay, and then the weed was found where?
Under the passenger seat where defendant Jackson was sitting
In what?
in a 2 small black bags.
How do you attribute the bags to her?
Your Honor, they were just located on the side of the vehicle where she was sitting.
So could be his. Okay, just puts it there. I don't know.
Yes, Your Honor, but the affirmative link would be in the proximity of where she was sitting as well.
Have anything else that identifies the bag as hers? The guy is the person's a guy, right?
Yes, Your Honor.
Okay, so is there a lipstick? Is there anything else that would identify the bag as hers?
No, Your Honor. All we have is that it was located on the passenger side glove box, just those 2 small black bags.
Glove box.
Yes, Your Honor.
Absolutely.
It was in the glove box.
Stop it. Are you losing?
Yes, Your Honor. That's all we have.
Okay, I'm gonna find no probable cause. Be careful with the company.
Y'all. As soon as she tried to start talking and tried to incriminate herself, he's like, stop. Are you losing? Stop talking. And then he goes on to say he cannot find probable cause in this because she was not in possession. The car was in possession. So I really like this judge. He is a hell of a judge.
You keep. When you hang with dogs, you get fleas, Miss Jackson. You know this. Come on. All right, please, just take a seat. I don't know why you're looking back there. There's nothing back there for you now. Mr. Waters, you were charged with criminal trespass. You're facing 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On September 26, 2024, officers self-initiated a criminal trespass investigation at a convenience store in Harris County, Texas. The officers entered the store and observed the defendant leaning on the front counter. The officers knew the defendant by name and sight from prior interactions and knew the defendant had been previously criminally trespassed from the location. The defendant was detained and identified with previous booking photos.
You picked up a theft at the same time. What, is that out of the same transaction?
No, Your Honor.
What happened with this? Because it's the same day, same filing date.
Says that the theft took place on August 28th.
Let's go through your history, Mr. Waters. January 23, you picked up a criminal mischief and you picked up a criminal trespass. On that day, you also get charged with 4 counts of theft. Theft. 2 months later, unlawful carrying of a weapon. After that, On the same month, you pick up another 4 counts of theft. So now we're at 8 thefts. A couple months later, another theft and an interference. Now you pick up an evading arrest, and a month later you pick up another criminal trespass and now theft as well. Where are all these thefts from?
Your Honor, the most recent theft was at a gas station. And then the one before that, just for your information,
Counts of theft, what?
was at the Galleria. So they're at various locations, Your Honor.
So he's hitting different places then? Is that what,
Yes, Your Honor.
this is newest theft?
The newest theft is a gas station, Your Honor.
I'm not giving you another PR bond. You're on bond for this case and now you picked up another case. Just over.
He said they will write an affidavit about it, cause the man said I would never trespass. We could call him.
Well, I will give you a lawyer today and we'll figure it out, but
Some of them they
Stop.
put them on me.
Okay.
I ain't got the officer badge on us or nothing, bro.
Deputy, get ready. Because I don't know. All I know is, Mr. Caldwell, you were on bond for a felony retaliation, felony aggravated assault of a family member, violation of a protective order with us, an interference, and then you pick up another felony retaliation. And we ordered you to be under 24-hour house arrest. And all I know is that on 2 different occasions, you left the house. What are you looking all confused about?
Judge, can I,
It's if you left the house or not.
Judge, can I
Yes,
explain
sir.
a little bit of the
Yes, sir.
situation? So,
Hold on,
yes, Judge.
please.
So, Judge, he lived with the complainant before these cases in a house he rented, and because of the no conduct condition, he moved back in with his mother, who he had been financially contributing to the household. Because of the house arrest, he wasn't able to work, and so he hadn't been contributing financially. His mother became upset with him, and so kicked him out, and then he contacted pretrial to let them know. And then he explained to his mother that if he doesn't go back in, he's gonna possibly go back into custody because of this house arrest. So it was really just sort of an issue with his mother and where he's staying right now, because he had previously been contributing financially and in part taking care of his grandmother. And she was kind of thinking he was just lousing around the house, and then he had to explain the fact that he had this 24-hour house arrest. And he did contact pretrial as soon as it happened.
Rachel, do you see that?
Yes, so he called pretrial on September 21st and explained that whole situation, living with his mother, leaving for something about a car. They advised him that it would be a problem for his ankle monitor, and then because it was after hours, it was just someone at JPC that talked to him and told him to call back during business hours. The next time he called was not until 9/27, and he was stating at that point that he had a problem with his charger, and it seems to be a shortage, they told him to come in. I don't see that he ever came in. And then on 9/30, it's stating that he's losing service. Plan to report to pretrial report. They told him to bring a charger. So basically, it was just a back and forth conversation about bringing a charger, not bringing a charger. And then violations.
Well, Judge, he contacted the emergency after hours number.
Yeah,
And
they have everything written down. There's nothing about mom. All I know is that and so do we have just Rachel one time that he took off from the house?
Yes, it's only that one day now. On 10/3, there was no cell for 6 hours from 9 to yesterday. There was no cell return.
What does that mean?
There's no signal going to the device. So what the officer said is basically the device was charged just enough for it not to be toward their battery, but the signal wasn't there for 6 hours. So it wasn't tracked. But he
6
did
hours,
call.
we have no idea where you are.
Oh.
Take off another day.
That's what they was calling about. They were saying, come report the pre-charge because of my charge. And I had told them I had court like the next day, and I was like, I'm gonna report the pre-charge so when I go to court, and the officer agreed to it. The officer sat after court, come right to pre-charge.
So the first conversation about the mother started 9/21, September 21st.
Mhm.
He didn't call back again until September 27th, stating he had a problem with the charger. But then on the 30th, he said that he was gonna come after court, which I'm assuming the court date.
Yeah, I supposed to have court on them first, but
Right, we had court originally on the first judgment. Because of the bond violation report, we set it was set to today.
Why no 6 hours? Why no?
I don't know. They had kept calling me saying that my charger, they bring my charger in because it's saying like no signal. And then I was telling them,
Did you go in?
No, it was like 4:00. She was like, just come right after court. It was like 30 or something, but I had court that Monday. I had court on the first.
And Judge, he was ready to come in court on the first, and
I don't care.
yes, Judge, I just.
All I care about is there's 6 hours that are unaccounted for. We have no idea what he's doing. We have no idea where you're going.
Oh, no, that wasn't my fault. That was the charge.
That is your fault. The device is not working and they told you to come in and you didn't go in.
Oh, no. She told me to come out the court. She told me to come out the court.
Is that right?
One day, they told him, because he told him he had court the next day. But the first day, he told him to come.
But so there's 6 hours unaccounted for and they just told him to come the next day?
No, the 6 hours was yesterday. That was what was unaccounted for. This conversation happened on the 27th and the 30th.
Okay, I'm worried about the 6 hours that are unaccounted for yesterday.
Oh, that's why I was gonna go to pre-trial at the court because they called me like twice saying my charger was doing that. She said it's only charged, and I did report to her that like when I plug my charger up, it'll like prolong for like 30 seconds, and when I take it off, it'll let me know it's off for 30 seconds. So I did let the lady know I'm like something wrong with it.
How can we account? How can we account where he was during those 6 hours?
We can't. There is no signal to the device, so there is no tracking to it.
She said
I'm not done with that. You could have been anywhere in the city. I have no idea
Oh
where you
no,
are.
I ain't going nowhere, sir. I ain't going nowhere.
I don't know that.
Yes, sir.
But Judge,
sir.
I don't think it'd be right for him to be punished if it's a defective device. If there's something wrong
And
with
it's
the
his
device.
responsibility to immediately go to pretrial, not wait the next day until you have court so you can do all in one.
That was a Friday, Judge. It was a Friday.
It was yesterday.
No, they're referring to this
Oh,
6
the-
hours.
I'm talking about the
Okay,
6
sure.
hours that are unaccounted for. You could be out and about doing whatever you are, harming my city. And I'm trying to protect my city when you've got 4 serious violent felonies open.
I didn't know it did that yesterday, though. I didn't know it did. I didn't get no call or nothing about it.
What, is he playing Helen
No,
Keller?
this-
What
this
the
is another
hell?
time.
He's referring to different incidents, Judge.
Yeah, I didn't
I
know.
am only talking about the 6 hours that are unaccounted for. Put everything else out of your mind.
Sir.
I'm only talking about the 6 hours.
He looks over at the court clerk. He says, "Is he playing Helen Keller? What the hell?"
If I get another damn thing at 4 in the morning, I'm gonna freaking lose it. Wake up the entire nation over this damn 4 in the morning.
Got a blue warrant today that woke me up.
Nationwide test all over from FEMA.
Wake my ass up 15 times at 4 in the morning. I know I did, but I'm already awake.
No, like turn it off from alerting you.
I know I did that, but I'm already awake. 4 in the morning, wake up my wife who's now bitching at me to turn it off, and then all the kids too.
Was that a blue warrant, Judge? I got a blue warrant notification this morning.
Bottom line, you're unaccounted for 6 hours. We have no idea where you're going. We have no idea what you're doing, and I'm not done.
I don't know. I didn't know about the.
So there is something going on with the device. He has to just get the device checked. I don't know.
So I want to send him right now to go get the device checked to see if there's a problem with it.
You'll be charging.
No, ma'am. I didn't.
Can you not go get it serviced without the charging
No,
device?
it's just, they tell them bring the charger. So like the officer kept telling you to bring your charger.
Yeah, she was like, when I leave court, go to,
Right, so you have your charger?
yeah, I have it. I have one.
Where is it?
It's in the car.
Okay,
so
I want you to go
Okay.
get the charger. I want you to go take it to where is it Smart Start? Where?
No, no, 49.
Okay, go there and I want to see if there's something wrong with the device.
Sure.
If there's nothing wrong with the device, then we'll have another hearing. And I'll see you back here on Monday morning.
Sir.
But No, I'm not down with 6 hours unaccounted
No, I
for,
understand, Judge.
and then he's leaving on another day. I'm not done with that. You have strict
Sir.
bond conditions that you have to adhere to, and when you don't, there are consequences. That's it.
I ain't know the charger, I mean, the device did that though.
So something's wrong with
Yeah, cause they'll call me and tell me and everything, but like I didn't get called.
So I wanted to stop it for a second and say one of the reasons why I really like this guy is because he's transparent and he holds his prosecutors and the public attorneys, the public defenders, accountable. He is awesome. Every single day, he's posting these public sessions. There aren't very many judges who do that, and he's completely transparent and accountable.
And they did call you, and they did tell you, and you still didn't go. That's
No, to my yesterday. They didn't call me and let me know like something's wrong with the device and then. Yeah.
so now. Where are you living now?
Still my mom. I had ended up explaining to her like why I had lived. When I first came, I told her like, Mom, I'm gonna end up staying with you for a while. And then she was like, okay. She not understanding like it's a 24-hour house arrest though. So like when I had ended up leaving, I had called her back and explained to her like, Mom, you know I can't go nowhere. That's
What's your mom's phone number?
I'm writing down.
Oh, that's right. Write your mom's phone number. I'm gonna call her right now.
832.
No, hold on.
Just write it down right here, okay?
What's your mom's name?
Gilbert.
Virginia?
Yes, sir.
Regina?
Gina. Yes, sir.
Your call has been forwarded to voicemail. The person you're trying to...
She not working.
What's that?
She probably asleep. She.
Hello?
Is this Miss Regina?
Yes.
Hi, my name is David Fleischer. I'm a judge here in Harris County.
Yes.
I've got Mr. Adrian Caldwell in front of me.
Yes.
And I don't know what you know about this case, but he's got 5 very serious cases open. One of his bond conditions is that he's supposed to remain under house arrest for 24 hours a day.
Okay.
And I want to make sure that that's okay with you, that he can stay with you under 24 hours house arrest.
Sure.
Is that okay?
Yes. Yes.
Because he's trying to tell me here that there's a problem and that he might get kicked out or whatnot, that he's got to leave. And I want to make sure that wherever he's going, wherever he's staying, he's allowed to be there, and that the persons know full well that he's not allowed to leave the house.
Okay.
Are you okay with this?
Yes.
Okay, you and I are now on the same page. There's no excuse for you to leave the house. If you leave, I will revoke your bond, and then you will stay with me. You will have house arrest with me.
Sir.
As it stands now, you're not off the hook. I want to see where those 6 hours are. We will send you to go get your device checked out to see what they can take. And then we'll see you here back on Monday. Okay. Thank you so much, Miss Regina. Take care.
Okay, thank you.
Yes, ma'am.
All right, y'all. That's pretty much what I got here for you today. Let me rewind the chat and see what I missed. For anybody who's still in here, I know I got like freaking 5 people watching. That's how you know I'm shadow banned as hell. Got almost 15,000 subscribers. I only got 5 people in here, so let's rewind the chat real quick and see. I'll do it over here. I'll do it over here. Where is it? Where is it? There it is. So we're just gonna scroll to the top. What do you mean stop breeding? Stop breeding. That doesn't go all the way back. What's happening here? So I don't see Jenny in here anymore, but hey Jenny, hey Lou, hey Lori Croft, Michael Reed. I don't know who's left in here. One track minded. That's why I like those other guys. I'm out of here. What does that even mean? Look, this guy right here, this guy in the comments. He said, but it's in the MCL. You have to list your name and address to get information. One track minded. That's why I like these other guys. I'm out of here. What? What? One track minded to try to defend our Fourth Amendment right? Our freedom to be secure in our person's papers and effects? What do you mean one track minded? That doesn't even make any sense. Get out of here. I don't want you here anyways. Clown. You sound good reading this stuff. No Diddy, he says. AT says. So what's up, Keith? I don't know if you're still in here, but we were doing a FOIA reading, and then we did some Judge Fleischer. Now, these Fleischer Zoom calls are over 4 hours long, and if you guys want me to do them with my own edits and stuff like that, it's going to take me quite a bit of time, so I need to know that there's interest in it. But that is just a fraction of what there is out there for Judge Fleischer. He's very, very level-minded and fair. I love him. I love him. I can't believe I was 46 minutes in by then. I was trying to make this less than an hour long. Samson, I don't know if you're still in here. You can turn the FOIA into anybody. You don't have to turn it into the FOIA coordinator. It is the duty of the public body to forward that information and that FOIA request to whoever it needs to go to. My day was pretty good. My day was pretty good, Gamer Kid. How was your day? I went auditing. I went and did some Snowflake Showdown content. I hope that that's something that you guys end up liking, because I'm putting quite a bit of effort into it and quite a bit of time. I think it's hilarious. I think it's funny. I mean, I seeing the different reactions from people with the different signs is it just blows my mind. I got a couple of people who were just, what is going on with my YouTube? Interesting. It's like looping in the corner. But anyways, it's funny because you can see them be hypocrites right on the camera. In the second episode, I'm in St. Clair Shores doing it, and I have the Kamala Harris sign out, and this lady screams and yells at me out the window. And then like 15 minutes later, I have the other sign out, and she gets done doing whatever she was doing and comes over to me to try to take a picture of me with my Kamala Harris sign. And now I have the Donald Trump sign out, and she's flustered. She doesn't even understand what's happening. It's funny as hell. And she's like, well, I had an issue with the one sign, but now that you have this sign out, I don't really care about the F word. And I'm like, well, there you go. And she's like, yeah, that makes me a hypocrite, doesn't it? Gamer said, so he's a guy, so he was talking about the TikToker named Amigo Chino, and he said he's a guy from Boston who crashed his car into a McDonald's and got on house arrest and is currently on the run after removing his ankle monitor on TikTok Live. What an idiot. What a straight-up idiot. They're going to get him. He'll get found. I mean, it's just about dumb. About dumb. Yep, Artemis, that guy does sound like a bootlicker, because what does that even mean? What does that even mean? one-track minded because it says it in the FOIA. It says it in the MCL. So if you're still here, damn it, man. Stupid ass name, by the way. If it says it in the MCL, does that make it supersede our constitutional rights? Or it's unreasonable searches and seizures. I think when I can make correspondence through email and pick something up in person without reasonably surrendering my Fourth Amendment, if I can do that, then why is it in the FOIA? It's in the FOIA because they want to be able to know who's grabbing the information so they can retaliate against them. Simple as that. Simple as that. So another thing, when I went to get the information on my last video, when I went to get the names and badge numbers of the people who refused to identify, when I went there, I wasn't recording with my phone out. I wasn't even video recording. I actually just decided to do an audio recording, which I will put on here. We will do a video and I will show you guys. I did an audio recording, and even without a camera, the disdain for the public. You have to press the button to get buzzed into the lobby or whatever it is. And I told them I was there to file complaints and commendations. So they let me in. And even though I was filing complaints on the bad behavior and commendations on the good behavior, there was two officers there besides the girl at the front desk. I was telling the girl at the front desk I wanted to file complaints, blah, blah, blah. These two officers come out and they're like, well, what's your name? What's your name? I'm like, oh, yeah, my name's Anthony. Nice to meet you. They're like, what's your last name? I'm like, I'm not going to give you my last name. They're like, well, we can't take a complaint unless you give us your last name. And that's the same thing as the MCL. It's the same thing because they want to know who I am so that they could possibly retaliate against me if they have to, or if they want to hold records, or if they want to do anything that the government's not supposed to be doing. They need my name. There's no other reason to need my name. Luckily, I had a fantastic female lieutenant come out, put them in their place real quick, take my complaints and commendations, give me those names and badge numbers, no problem. And I told her, hey, you should be chief. You should be chief. And she's like, no. I'm like, what about deputy chief? She's like, no. I'm like, so you've gotten to the point that you want to get to. You don't want any more responsibilities. And we laughed. And she's like, yeah, that's what. I'm like, well, I'm happy that you got to the point that you want to get to in your career. I'm happy for you. And I don't think I said I'm proud of you, but I meant to say it because she did a great job de-escalating, telling her officers the correct information, and making sure that I got the information that I needed. She served the public fantastically. But I think that's it, y'all. I think that's it for tonight's live stream. I didn't have too many people in here, which isn't a big deal to me. Let me know if you liked the Judge FLEISCHER content. The Judge FLEISCHER content can be a category of its own, and I would like to do it because I like his style. I really do. With that said, we are going to get the hell up out of here, and we will see you in the next one on Wednesday at the crash for the Roseville PD, where the officers, I'm not going to give you any spoilers, but there's a pretty hilarious sound that I have on the soundboard of the Discord that came directly out of one of my audits. And it was actually the audit that I did there for the crash with the Roseville police station. Let's see. Where did I put that? I don't even know where I put it, to be honest. Beep, beep, channel. No, it's not under documents. I don't know where I put it, y'all. No idea. It should be. I swear it was under editing audio, but maybe it's under audio clips. Yeah, it's right here. It's right here. Let's see if you guys can hear this.
Yeah, wait till my husband comes and documents your face.
Can you guys hear that? Can you hear it? I just tell this lady. So I've been there for like 20 minutes already, and I've been silently just documenting the experience, and that's what I tell her. Like, it's like 18 minutes in. I haven't talked to her. I haven't even talked to the officers. I just told one of the officers when I was crossing the street, like, yeah, like, I don't need the directives. I know how to cross the street. And I come back around, and she's talking to the officer. And as I turn around, like, I'm panning around to where the officers are at because I don't even care about her. I pan around, and as I'm not even facing her, I hear her say, "Who the fuck are you?" And I turn back to her, and I'm like, "None of your damn business." And then it ends up saying, so I end up saying, like, I'm just here to document the experience. And then she's like, "Oh, yeah? Wait till my husband comes and documents your face." Let's play it again. Let's play it again here. Is the volume up loud enough? Yeah. Ready?
Yeah, wait till my husband comes and documents your face.
So her husband did show up, and it's actually on one of my shorts. If you want to go check out my shorts, I'd tell him to back up. Like, don't come at me. I'll whoop your ass. Like, I ain't even worried about it. And honestly, I should have whooped that one guy's ass who came at me. I should have whooped his ass. I was trying to de-escalate it, though. But now it's a star video on the troll channels because an auditor got beat up. Like, no, I was de-escalating. I could have fought him, sure. I could have fought an old man, no problem. But I just wanted to de-escalate. But since that altercation, I have taken a more firm stance on my defense. So that's enough for the sneak peeks for Wednesday's video. With that said, I think we are going to get the hell up out of here. And I think I had fun tonight. Even though I didn't have a ton of people in here, I think we had fun. So I'll see you in the next one, y'all. Public tour. Peace.